Hello everyone. Today we will discuss about part 2 of the Limitation Act 1963, which deals with the provision relating to the limitation of suits, appeals and application. The limitation period is expressly specified in the schedule. But today we will deal with the various situations where the limitation arises. I will hereafter discuss section by section the various situations when an application, suit or appeal will be barred by limitation. The first section that we are going to deal with is section 3. Section 3 lays down the general rule that if any suit, appeal or application is brought before the court after the expiry of the time so specified in this act, the court shall dismiss such suit, appeal or application as being time barred. But the law of limitation only limits the judicial remedy, but does not extinguish the right that is related to it. As it is rightly said by the Supreme Court in Punjab National Bank and others versus Surendra Prasad Sinha, that the rules of limitation are meant only to destroy the rights of the parties. However, there is an exception to this rule, which is laid down in section 27, where any person who has a rightful possession over a particular property does not claim it within the time so specified, he loses the right to it. For the purposes of this act, it is also defined in section 3 the institution of suit. What is the meaning of that? The suit is said to be instituted if in an ordinary case it is presented before the proper office. In case of claim against a company which is being wound up by the court when the claimant first sends his claim to the official liquidator, and also an application by notice of motion in the High Court is made when the application is presented in the proper court of justice. Any claim by way of setting off a counterclaim shall be treated as a separate suit and shall be deemed to be instituted when, in the case of setting off on the same date on which the suit is set off to be pleaded. In case of a counterclaim, on the date on which the counterclaim is made in the court. However, if the period prescribed for any application expires on the day on which the court is closed, then the application, suit or appeal shall be made on the day on which the court reopens as per section 4. That is, suppose the last day to file your appeal is on 13th of September 2020, which is a Sunday. Your limitation period will be counted till 14th September 2020, which is a Monday and a working day for the court. In the explanation of part 4, it is mentioned that a court shall be deemed to be closed on any day within the meaning of this section if during any part of its normal working hours it remains closed on that day. This means that if it is a national holiday or it is any other day for any reason the court is closed, then that day will not be calculated within the period of limitation. Now, if we cannot file an application, suit or appeal within the limitation time, we can condone for our delay. Condonation of delay means requesting for the extension of time given in certain cases provided that there is a sufficient cause for such delay. Section 5 deals with that. Section 5 talks that the extension of the prescribed period in certain cases. It provides that if the applicant or the appellant satisfied the court that it has a sufficient cause to defer the appeal or the application and could not file it within the prescribed time, such appeal or application can be admitted after the prescribed time as well. This section further mentions that an application made under Order 21 of the Code of Civil Procedure then it and shows a sufficient cause, then it will also be admitted. Sufficient cause means that there should be an adequate reason or reasonable ground for the court to believe that the applicant or the appellant was prevented from proceeding with the application in the court. The explanation to section 5 states that ascertaining or computing the period so prescribed when an applicant or an appellant has been misled by an order, practice or judgment by the High Court, it will also be a sufficient cause within the meaning of this section. However, if a party does not show any cognizant ground for the delay of application, suit or appeal, it will be rejected by that court. In a very well-known case, the court held that whether or not there is a sufficient cause for the condonation of delay is a question of fact and the dependent upon the circumstances of a particular case. Now we move on to a very interesting part which is laid down in section 6 and 7 about the legal disability. Legal disability can be a cause of delay for the institution of suit, appeal or application as it is described in section 6 and 7. Legal disability in the Act means minority, lunacy and idiocy. For the purposes of this Act, a child in a womb is also considered to be a minor. So, we will deal with the first situation here. If a person who is entitled to institute a suit, appeal or application was affected by any of the discussed legal disability, he will institute a suit after his disability ceases. For example, if the property of the deceased was wrongfully partitioned without the minor given his particular share and it was within the limitation period and it was exhausted, the limitation period now exhausted when he is still a minor. The minor can institute the suit after he is a major within the period so prescribed in the schedule. It is in the third column. The second situation is that when a person at that time when the prescribed limitation period has started is affected by two disabilities, or where before his disability has ceased he is affected by another disability. He may institute a suit or make an application within the same time after both the disabilities have ceased, as would be otherwise have been allowed from the time so specified. This can be described by a simple example. A lunatic minor of a deceased is deprived of his share of property. However, the minor, even after attaining majority, he is still a lunatic. He can apply his right after he is cured of his lunacy. Another example can be, if a minor of a deceased is deprived of his share of property and he becomes a major just before attaining the majority or at the date of attaining majority, he becomes a lunatic. He can apply for his right after he is cured of such lunacy. Situation 3. Where a legal disability continues up to the death of the person, his legal representative can institute a suit or make the application within the same period after the death as mentioned in the schedule. Taking the same example, if a lunatic minor person remains a lunatic till his death, his legal representative, if any, can institute a suit in his absence to restore his rights. Situation 4. Where the legal representative referred in the previous case at the date of the death of the person whom he represents affected by any disability, he shall be treated similarly as the previous rightful applicant. Taking the same example, a minor lunatic is deprived of his right and he has died leaving behind his legal representative who can now institute a suit in his absence. But the legal representative that he left behind is also a minor. Then he can file the suit when he is a major. However, on the date of attaining majority, he becomes a lunatic. Then he can file the suit after he is cured of such lunacy. Situation 5. Where a person under disability dies after the disability ceases, but within the period allowed to him under this section, his legal representative may institute the suit or make the application within the same period after the death, as would otherwise have been the case available if the person has not died. Again, taking the same example. A minor child who becomes a lunatic after he has attained the majority on that very date that he attains the majority, who is supposed to file a suit in the absence of the rightful owner. He also dies leaving behind a legal representative. He was cured of his lunacy within the limitation period so prescribed. Then the legal representative that he has left behind can claim for his rights. So there is a difference between the two situations, situation 4 and situation 5. In situation 4, the curing of the particular legal disability was not required. In situation 5, it is required. The legal representative can only file after the lunacy of that particular person, that is the legal disability of the person, has ceased within that prescribed time. But in situation 4, it was not the case. Moving on. Section 7. When any of the several persons jointly entitled to institute a suit or make an application for the execution of the decree is under such disability, and a discharge can be given without the concurrence of such person, time will run against them all. But when no such discharge can be given, the time will not run against any of them until one of them is capable of taking the discharge without the concurrence of the other, or until the disability ceases. This section applies to the discharge of every kind of liability, including the liability in respect of an immovable property. To understand this in a simple manner, we take an example of a deceased father who leaves behind 3 minor sons and 1 major son. One is aged 3, 4, 16, and the major is aged 23. All the minors are deprived of their right to property by their elder brother, who is aged 23, by selling off the entire property of their father. Thus, the limitation period to restore the rights will be counted after the minor aged 16 attains majority, who is capable of taking discharge of the particular suit. And when the right will be restored, it will not only be restored for that particular person who has now attained majority, that is the 16-year-old minor who has attained majority, but also for the other 2 minors, which is aged 3 and 4. For the purposes of this section, the manager of a Hindu undivided family governed by Mitakshara law shall be deemed to be capable of giving discharge without the concurrence of other members of the family, only if he is in the management of the joint family property. Section 8. Section 8 simply states for the limitation period after the disability is ceased or the death of the person is effected. To enforce the right of redemption, the limitation period will not extend for more than 3 years for the cessation of the disability or the death of the person affected thereby for any suit or application. So section 8 states the limitation period after the disability ceases. Section 9. Section 9 lays down that where one time has begun to run, no subsequent disability or inability to institute a suit or make an application stops it. For example, if a minor of a deceased is deprived of his rights as a legal heir, he attains majority, and after the date of attaining majority, he becomes a lunatic. The calculation of the limitation period starts from the very next day, and if he is becoming a lunatic after the date of attaining majority, it will not be considered and the limitation period will continue to run. But there is a proviso in this particular section. It provides that where the letters of administration to the estate of a creditor have been granted to his debtor, the running of the period of limitation for the suit to recover the debt shall be suspended while the administration continues. Moving on to the next section. The next section is section 10, which lays down that notwithstanding anything which is contained in the foregoing provisions of the Act, no suit against a person in whom the property has been vested in trust for a specified purpose or against the legal representative or assigned for the purpose of following his or their hands such property or proceeds thereof for an account of such property or proceeds shall be barred by the length of time. As an explanation, for the purposes of this section, any property which is comprised in a Hindu, Muslim or Buddhist religion or charitable endowment shall be deemed to be the property vested in trust for a specific purpose, and the manager of the property shall be deemed to be the trustee thereof. Now we come to the last section, that is section 11. This is the last section of this part. Section 11 states that any suits or contracts entered into outside the territory of India shall be subject to the rules of limitation of this Act, and no other limitation law in force in that particular foreign country shall be a defense to institute a suit in this territory on the contract with that foreign country, unless it is the rule has been extinguished in the contract, the parties are domiciled in that state or foreign country during the periods so prescribed in this rule. With this, we come to the end of the video. I hope it was helpful, and we will surely catch up in the next video for part 3. Thank you.